You struck the officer in the right side of his face with your hands. You punched him. This isn't a debate. I'm speaking. Don't be rude. You get a chance to speak, but don't speak over the court, please. This isn't a debate and an argument, okay? We now call cause number 26 CR 909, the state of Texas versus Clinton Thomas Edmondson. That's you, sir? Are you Mr. Edmondson? You have to speak up so she can hear. She's the court reporter. Good. Thank you.
I don't make mother's name.
I'm sorry.
My mother's name got covered over for old age. I was in jail before. They gave me a name like this for the hospital.
But you are Clinton Thomas Edmondson. And you are charged in this cause number 26 CR 908. Here's the indictment here. With the second degree felony of assault on a peace officer. And this states that on or about March 5th, 2026, this year over here, on or about March 5th, which would have been April, May, June, July, August, 5 months ago, in Jefferson County, Texas, this states that you intentionally, knowingly, and recklessly caused bodily injury to the complainant, a police officer. Don't interrupt me. By striking the police officer in the face with your hands. And that you knew that he was a peace officer lawfully discharging an official duty.
I don't remember hitting no police officer.
This states that the police officer responded to the report of a person with a white hat and tan pants, and that was described as you, breaking the window of a pickup truck while trying to assault the person with a metal pole. This happened on Magnolia Avenue. The police arrived, saw you, and called for you to stop as you were walking away. You were holding a fence post, and you dropped the post and stopped. When the police began to pat you down for weapons and safety, you struck the officer in the right side of his face with your hands. You punched him. This isn't a debate. I'm speaking. Don't be rude. You get a chance to speak, but don't speak over the court, please. This isn't a debate and an argument, okay? And there was a struggle, and then he had to activate his taser, and you were finally subdued and cuffed. The owner of the property at 350 Magnolia said he had told you to leave the property because you were trespassing. You became angry and threatened him with the fence post. So you are charged here with the second degree felony of assault on a peace officer. If convicted, you are looking at no less than 2 nor more than 20 years in prison, and a fine up to $10,000 can be assessed. Oh, do you understand what you're charged with and the punishment range applicable here?
Do you understand what you're charged with?
Understand what you're charged with and what the punishment range is, up to 20 years in prison, if convicted.
That's your question?
No, you're going to get a chance to speak in a minute. Just, do you understand what you're charged with? But I just read to you in English, and the punishment range of up to 20 years.
I don't know. I don't mean no harm, but I don't want to say the wrong thing because I know who I am. I know who I am. I got shot on the front premises. I got shot on the front premises way before.
We just need to know whether or not you understand.
Nobody else, I don't know.
There's nothing about
I don't have
a
no
shooting.
friends walking the street. Someone was talking to me, and I don't know their conversation.
Okay.
But when it's
All right. So what we're going to do
I
then
don't know who's who.
is,
So
do you know who
I mean,
you are?
getting hurt.
Do you know who you are?
Yeah.
What
but
is your name?
I went somewhere, but I'm hearing bad things. They told me, like I said, if I wasn't welcome to paying for noodles or soups.
Okay.
What's your name?
All
Clinton Thomas Edmondson.
okay. That's right. You're right. You're charged with striking a police officer. That's why you are here, sir.
No, I don't.
Yes, it is while you're here. I'm not debating you.
Judge, I think he was just answering the allegation. It's just the allegation.
All right.
Not to-
What we're going to do is set this on a trial. We'll let a jury decide your fate, okay? And you're looking at up to 20 years in prison. And Mr. Turk, why don't you get with us if you need to
Yeah.
file any other motions, if you know what I mean. That's what we're going to do until then. We're going to set it for trial. That is all.
Don't take you up anywhere.
You supposed to be alone?
Yes.
Next is Lucy Johnson.
Okay. Don't say anything else.
Next is Lucy Johnson. Thank you. Okay, you're Mr. David, Dedric Davis, and you're here with Mr. Turk, your attorney, and the state's attorney. What's our plan? We've got two cases here. 26 CR 828, theft of property, and
We have an agreement of 2 years state jail on the state jail offense with 2 years TDC on the other to run concurrent, Judge.
then you got obstruction. The other one is obstruction, which is a third-degree felony.
Correct, Judge.
All right. And you are Dedric
Yes, sir.
Davis,
Yes, sir.
and Mr. Turk is here. Does the defendant waive formal readings of the indictments and the arraignments here? Can we proceed in summary?
Yes, Judge.
26 CR 828 first. In summary, this indictment alleges that on or about March 13th, 2026 in Jefferson County, Texas, you committed the offense of theft, and even it was involving food of a value of less than $2,500. But paragraph 2 goes on to allege that you have 2 or more prior convictions of thefts, 1, 2, 3, 4, 5 convictions out of county court at law 2 of Jefferson County, Texas, and out of the 252nd District Court of Jefferson County, Texas. 3 of those are misdemeanors, 2 are felonies. Paragraphs 1 and 2 will constitute a state jail felony, which means you are looking at no less than 180 days up to 2 years in the state jail. And a fine up to $10,000 can be assessed. Do you understand what you're looking at, sir?
Yes, sir.
All right. In this case, an agreement's been reached where you would be pleading guilty, sentenced to 2 years in the state jail. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
What's our plan in the other case?
2 years, Tennessee, 2.
Are those going to be running concurrent?
Yes, sir.
And that's not shown here in the,
It is the agreement, Judge.
okay. I'll put that in. All right. Once again, if I follow this agreement, you have no right of appeal of your case. Do you understand? Also, the 2 years will run concurrently with the other case. Okay. If I follow this agreement, sir, you have no right of appeal of this case. How do you plead to this? Guilty or not guilty?
Guilty.
Sir,
I plead guilty, sir.
are you pleading guilty voluntarily and because you are guilty?
Because I'm guilty, it's voluntary.
And voluntarily. Nobody's forcing you to do this. You're doing it on your own free will.
Yes, sir.
Okay. That one aside for just a moment and go to the second case. In this 26 CR 959, this second case alleges that on or about April 30th, 2026, in Jefferson County, Texas, you committed the third-degree felony of obstruction or retaliation. Essentially, it states you intentionally or knowingly threaten to harm another person with assault in retaliation or in account of the service of that person who had reported a crime. I guess it must have been the theft case. No, it was something else altogether. All right. Do you understand what you're charged with, though?
Yes, sir.
This is a third-degree felony. If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed that would exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached in your case where you would be pleading guilty, sentenced to 2 years in prison, and this is going to run concurrently.
Yes, sir.
Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this case? 26 CRA 2, I'm sorry, 26 CR 959, the third degree felony of obstruction or retaliation. Guilty or not guilty? Guilty. Be pleading guilty voluntarily and because you are guilty. Yes, sir. And because you are guilty.
Yeah.
Okay, yes.
Yes, sir.
Yes, but in each of these cases, State's Exhibit 1 states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read them. You are guilty of the crimes charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true at State, so help you God.
Yes, sir.
Okay. State's Exhibit 1, in each case made a part of the record for all purposes. Pre-sentence reports are waived.
Yes, Judge.
All right. Mr. Davis, I'm going to follow these agreements. I'm going to find in each of these two cases you have pleaded guilty to. You have entered your guilty pleas voluntarily, knowingly, intelligently. There was sufficient evidence supporting your guilty pleas from State's Exhibit 1 in each of these cases where you waived your rights to appeal and waived your rights to a jury trial to enter your pleas of guilty. State's Exhibit 1 and your plea of guilty, your sworn statements stipulating that you are guilty in each of these cases. That is enough to find you guilty beyond a reasonable doubt in each of these two cases. I now find you guilty in 26 CR 828, the state jail felony of theft. You were theft. You were hereby sentenced to confinement in the state jail for a term of 2 years. And in 26 CR 959, the third degree felony, obstruction or retaliation, I find you guilty of that third degree felony. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 2 years in that case. These sentences shall run concurrently. Do you understand what's happening?
Yes, sir.
All right. Good luck to you. Yes, sir. Do better. You can do it.